This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. A high-profile case ended in a mistrial because an attorney spoke to the media. Is that enough to end up in hot water with the judge? A group of residents is suing to block a data center headed for their backyard. Is secrecy around the government's actions enough to invalidate its approvals? And a local police officer found himself demoted over a reply-all email. Could his lawsuit earn him his old job back? These are tough questions for good lawyers, and I have three of them with me here today. Yes, it's our legal roundtable. This month we have a great panel. We are joined by Eric Banks. He's a former city councilor for the city of St. Louis and an attorney and mediator at Banks Law. Eric, welcome back.
Thank you.
And today we are also joined by Mary Ann Sadeh. She's a partner at Sadeh Harper Westhoff. She is a nationally recognized labor and employment lawyer. It is always a blast to have her on the show. Mary Ann, welcome back.
Thank you.
And last but not least, making his legal roundtable debut today is Patrick Homaker. He's a former prosecutor with the St. Louis Circuit Attorney's Office. He worked in the Armed Offender Unit focused on homicides, assaults, and robberies, also handled officer-involved shootings. Today, he's an associate at Mandel, Marsh, Sudacum, and Sanger, where he focuses his practice on personal injury and civil rights litigation. Patrick, welcome.
Thanks for having me.
So, a high-profile trial came to a dramatic end. This was on Tuesday. Megan Green, the president of the St. Louis Board of Aldermen, has been suing the city ever since she was tear-gassed during a protest in 2017. That case has been going on for a long time, but it was finally set to go to trial this week. Well, on Monday, they started jury selection. On Tuesday, a few media outlets published stories about the case. That same morning, the prosecutor raised that as an issue. The judge was actually curious about comments that Megan's lawyer, Javad Kazali, made on this very show. He had called in the week before, and Javad said, hey, this was before the trial even started. But then he admitted, well, yesterday I talked to St. Louis Magazine while jury selection was underway. The judge called it foolishness, and she declared a mistrial. Eric, this strikes me as really unusual. There hadn't been an order not to talk to the media. Have you seen a mistrial over comments like this?
No, I haven't, but it certainly will have a chilling effect on my willingness to talk to the media.
Oh, great. Here we go.
Yeah, right. Well, I'm scared to death, so I'm going to really abide by the Joe Friday concept on Dragnet. Just the facts, nothing but the facts.
Yeah.
And there's going to be a lot of, well, as much as I would like to discuss this, it is pending litigation, and I don't want to run afoul of the ethical rules prohibiting trying a case in the media, yada, 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 which is an answer with no answer.
Right.
But I'm going to think long and hard before talking to the media.
And that's even if, say, we're like a month out from trial, you would still maybe be a little nervous because of this.
Yeah, and there's a school of thought that says that once you file the lawsuit, you should be bound by the pleadings and don't say anything other than the pleadings. So maybe a compromise would be, as much as I would like to discuss this, I'm not allowed to, so I direct your attention to the pleadings which are available to the public on either Missouri case letter if it's a state case or a PACER if it's a federal case.
Mary Ann, this breaks my heart a little bit as a journalist because I rely upon lawyers explaining to me what's going on, and I love it best when they explain to me on the record so I can then share their knowledgeable words with my readers, or in this case, with my listeners. But I see you nodding as Eric talks.
Yeah, I always take a very conservative view on this because you can get yourself in trouble, you can get your client in trouble, and truly, you never really know how the facts are going to come down in a trial until you're in the trial. So, I'm just careful about it. There isn't any blanket rule about it. There wasn't an order. I think it really depends on what you're trying to accomplish. I think in this case, it's a pretty highly political case, and therefore it would be likely that the plaintiff and the trial lawyer would want a discussion of it in the public. But, if I was concerned about that jury, I'd want the people who listen to you and want the people who read St. Louis Magazine. So I would keep my mouth shut, I think.
Interesting. So, Patrick, I feel like I'm a great viewer of Law and Order. You always see prosecutors on the courthouse steps there discussing with the media what happened in that day in court. Was that your experience when you were a prosecutor at the Circuit Attorney's Office?
Oh, absolutely. Going back to my time as a prosecutor, and even now, I take a pretty conservative approach whenever I talk to the media. I believe it was an informal policy within the Circuit Attorney's Office during my time to not necessarily engage with the media unless they went through the proper courses and supervisors and what have you. So just giving blanket statements in the halls or taking calls from reporters was not something that I engaged in or we were encouraged to engage in. The problem that I have with this comment that Javad made, and I love Javad, he's a very good attorney.
He's also often a panelist on the show. I want to say Javad will always be a friend to the show, mistrial or no mistrial.
Right. The judge has to balance, tainting the impartiality of the jurors versus judicial efficiency and having to bring in a new crop of jurors, the delay in the case. But when you kind of look at the Missouri Supreme Court rules on professional conduct, they really focus on whether or not the lawyers making a statement that they know or reasonably should know would be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicated procedure in the matter. The problem I have is he says if they're not willing to listen to the federal courts, if they're not listening to their own rules, eventually they're going to have to listen to jurors. That jurors, implicating them in that, is kind of probably the point where it gets too far for me.
That's interesting. Opinion. Yeah, that's where you cross the line. We do have a clip of something that Javad said. He called in to St. Louis on the Air last week. Let's hear just a short excerpt.
We have a trial that's starting on Monday against 8 St. Louis police officers who tear-gassed President of the Board of Aldermen, Megan Green. The officers have no idea if they lose the case, will they have to pay for it out of their own pocket? Because we're sure going to go after them.
Eric Banks, what strikes you hearing that quote from Javad Kazali? Well,
it seems to me that he is sticking with the facts, which is especially problematic in terms of what more can you do? I mean, he didn't overplay his hand, in my opinion. I think the main thing was he just talked to the press, and once again, it's going to have a chilling effect on my willingness to discuss anything pending with the press going forward.
Yeah. I do want to mention one rumor that I've heard. I love the rumor mill in this town, and I can now freely air this rumor, which I've heard that the real problem is a comment that his client made, that his client told St. Louis Magazine that if there was any sort of financial award out of this trial, that she would donate the proceeds to tornado victims. That may have been where the judge was like, I do not want the jury to know that. Marian, is it different coming from a client versus a lawyer? She doesn't have to follow those ethical rules Patrick was just quoting to us.
Well, that's an interesting question. I hadn't thought about that aspect of it. It depends on what you think is going to affect a juror. I mean, does that mean that the jurors are going to give more, give less? I mean, it's really hard to predict. I just think silence on most of this stuff is the best route.
And I think it's complicated by the fact she's the president of the Board of Aldermen.
Exactly.
Right? So
I'm calling her, and if she says no comment, I'm going to be like, Megan Green won't talk about the fact she's suing the city. That feels very unfair to her.
Yeah, I decide, where the judge is stuck in this position on balancing both things. And I think when, tie goes to the runner, the tie in this is going to be protecting the impartiality of the jurors. And I think that's what she's looking at. Are there other options she could have done? Perhaps, but it also kind of depends that, is the jury sworn in at that point? Does she have a time to rehabilitate them? But then are you making a bigger deal out of something that they may not even know about?
Yeah.
So it's just a really tough position that the judge was in, I think.
And when you say rehabilitate them, what would that mean in this case?
Yeah, I mean, for instance, I think you could basically void-ire the jurors about have they heard anything about this, and they generally do. But then after something like this comes out, the question is, do you void-ire them specifically with what is said, or at least the platform where it was said at? But
so
then
you would say specifically, like, have you seen anything this morning before you came in here today? Like that, try to press them on that.
And then the problem with that is, then you've put it into their minds. Well, what was said out there? What did I miss? And, jurors, I get it. Like there's a natural inclination. You hear that and you're like, what's going on? And you're prohibited, from reading and looking into the case. But, there's jurors are humans, you know?
And of the 80 or so cases, jury trials that I've had, they always include the same language. Don't look at the paper, don't talk about the case, don't tweet, don't Google, don't Instagram. Stay away from anything that might taint your opinion of this. Yeah,
that feels like that should be the mistrial, as if a juror was like, yep, I read that story and I didn't disclose it. And, I Googled this case the minute I got home while we were still deliberating. Like that to me feels like, of course, you're under such an instruction. I know, though, from having sat there on that panel, boy, are you just itching to pull out your phone and start Googling the main characters.
The other thing that's interesting about it is the jury selection was not complete. And once the jury is impaneled, I think people take more seriously their responsibility not to go Google and to stay off their phones. When you think, well, maybe I'll be on it, maybe I won't, it's a little early in the game. So, yeah,
so
I think that makes a difference.
Exceptionally bad timing.
Right.
I'm liking your theory on this. That actually makes sense to me.
Yeah, and that's the point I was trying to make. I couldn't tell based on the information I was given at what point it was declared the mistrial. But I do think that is a really, really important distinction. Had they been impaneled already or not,
That's a good question that I'm not clear about. I know that, they were doing all the, I'm going to mispronounce that. They were trying to choose a jury on Monday. This story came out at 6 a.m. on Tuesday. I don't know that jury had fully started what they were doing. Had they been given the instruction, we may never know.
And if the issue was not complicated, we wouldn't be discussing it.
That's right. That's a good point, Derek. And I hope that this won't provide the chilling effect, just selfishly here. But all right. Well, so that is an interesting case. We have another one we want to talk about today, where this one actually did go to trial. It just took a while for the judge to get to what is the final and most important ruling here. This has significant consequences for Missouri's once thriving gas station gaming industry. So this is the games owned by Wildwood-based Torch Electronics. They're everywhere in Missouri gas stations. Rival companies have long said they represent illegal gambling and unfair competition. No one really took action to do anything about this. Well, a competitor, this is called TNT, they sued Torch and they won. They got a $500,000 financial reward from this. And then just a couple months later, Judge John A. Ross comes back and says, yep, it's not just that you're going to get $500,000 for this. It's that these games actually represent illegal gambling. Marianne, what strikes you about this case?
Well, I'll tell you, the thing that strikes me the most is that gambling is becoming so ubiquitous again. I mean, I can barely watch sports on TV because there's so much advertising about the gambling. So it's not an area I know a lot about, but unfair competition is very difficult to prove. I mean, I have had claims like that. So, there must have been some really good proof in the case, and I don't know what that proof was.
Yeah, I understand. It got very technical. Like, they're like, if you put this money in, does this picture come up automatically? Like, is it always the same one every time you do it? Like, they really got into the weeds. It does seem very unusual that we're asking a jury to figure this out as opposed to government regulators. Eric, is that surprising to you?
No, it's not. I'm a big fan of the jury system. I think that 12 impartial people have just about as much chance of reaching the right decision as regulators. I disagree. Well, I don't think that you should have the machines in service stations. I think it's illegal gambling. I think it's wrong. And I just wonder where are we going to go with all this? I mean, and I can be a little bit libertarian on these issues, laissez-faire, but I just think that it's getting out of hand.
Yeah. These gas station games, people thought they were out of hand for years. I mean, this was a big topic in political circles, but these guys seem to have some political connections where nobody really wanted to take them on. I guess it took a competitor to hire an expensive law firm to bring this one.
Yeah, what I found most interesting about this, and I don't know the intricacies of the gas station gambling machines and all that, is that dichotomy between are the regulators stepping up, or do you pursue this civilly and have a jury decide this? And to what Eric's point is, that is the point of our jury system sometimes, is that, if government bodies are failing us, we do have that option to bring these cases into circuit courts and have a jury decide. I'd probably much prefer more regulation on the government to step in, not necessarily specific to this issue, but in other things, for instance, there was the other lawsuit with the marijuana companies going after the people that are selling basically, hemp-like sort of marijuana type things. I think issues like that, you would really hope that government intervention could come in and you wouldn't have to resort to these private lawsuits.
Yeah, I mean, you make a good point. And that one also in this last month, this is a coalition of cannabis, regulated cannabis, saying, hey, these guys are illegally selling marijuana. They've just figured out how to slide under scrutiny here. They now target nearly 40 stores in St. Louis County, 17 businesses in the Kansas City area, some major hemp chains. This could be sort of the next one of these lawsuits. I have a feeling we're going to be talking about that one for years to come. These things don't seem to resolve quickly. We're talking today to our legal roundtable. That is Patrick Hamaker, who's with Mandel and Mandel. We're also joined by Eric Banks, who's an attorney and mediator at Banks Law, and Marianne Sadeh, a partner at Sadeh Harper Westoff. We're going to take a quick break, but when we come back, we're going to talk more about Kratom and a lawsuit that says it destroyed someone's life. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our legal roundtable. Once a month, I get to pick the brains of some of the top attorneys in town. Always a treat. And today we have a great panel chewing on a lot of interesting substance today. That panel includes Marianne Sadeh, who's a partner at Sadeh Harper Westoff. She's also a nationally recognized labor and employment lawyer. We're also joined by Eric Banks, a former city councilor for the city of St. Louis. He's an attorney and mediator at Banks Law. And also today, in his legal roundtable debut, is Patrick Hamaker. He's a former prosecutor for the city of St. Louis, currently an associate at Mandel and Mandel. Patrick, you feeling good so far?
Yes, thank you.
Okay, now it's time for things to get hard. I'm going to bring this one to you here. A local man is suing the Kansas City distributor behind the product that he says destroyed his life. Joseph McGuire says he got hooked on 7-OH pills. These are a type of kratom that's distributed by Kansas City-based EDP Kratom. They're totally legal, even though medical professionals are increasingly speaking out, saying they have concerns about them. Now, McGuire says they have risks of addiction, dependency, and withdrawal similar to morphine and heroin. He says he even had to close his shaved ice shop that he owns in South County because his life spiraled downhill. He is now suing EDP Kratom. Patrick, does he have any hope of winning this lawsuit?
I found this lawsuit to be particularly interesting. So I have a background. I've previously represented several counties in the state of Missouri in the litigation against the opioid manufacturers and distributors. So when I first dove into this case, I had to learn a lot about what kratom is.
Yeah.
And so my understanding, it's a leaf that comes from a tropical tree from the Southeast Asia. It contains a substance that, when digested, turns into a chemical that has these opioid-like substances. The specific kratom that we're talking about as the basis of this gentleman's lawsuit is something called 7-OH. And what that essentially is, highly concentrated form of kratom developed through a chemical process, so in a lab. And we're talking about 90 to 100% concentrate, whereas, regular kratom, my understanding is, you're going to be really, really low amounts of that. So this lawsuit, though, it centers around marketing, specifically violations of Missouri's Merchandising Practicing Act. And it's similar to the opioid litigation in that the argument is that there's a failure to warn of the addictive nature of these products. When you dive into it, what's really interesting is that these 7-OH products were actually first developed by this company out of Kansas City, who white labels the particular product that this gentleman is suing with regards to in this lawsuit. This company was giving a written letter by the FDA back in June of 2025, where they were warned by the FDA about their illegal marketing practices. Ooh. And that also went to the white label company that is making and distributing this brand. What's further interesting is that the Missouri Attorney General's office has been undergoing an investigation of these products since last November. The Missouri legislature last year actually took a look at a bill trying to ban some of these substances. That ultimately failed in committee in the Senate. And then the Missouri Department of Health says that, these products can be 13 times stronger than morphine, and have urged Missourians to avoid products containing the substance. So, the question that I kind of have is twofold. If you're looking at this from a lawsuit perspective, the plaintiff is going to have to, prove that this is an addictive-like substance. And, in my quick studies, there is a lot of science to support the addictive qualities. The other question that I kind of have in regards to this is, again, goes back to the government role here, is where are they on regulating this? We're going back, almost a year now to the FDA sending a letter out to these. There seems to be ample evidence to suggest that this is pretty addictive substance. And, in my neighborhood, there was one of these kratom shops that opened. I think that there's some real questions about what the government is and isn't doing with regards to this.
I think you're right about that. And there has been debate at all levels of government. I've heard it in the city of St. Louis. I've heard it in St. Louis County. I've seen it happening down at the Missouri legislature. And in each case, it seems like there are people coming in and saying, oh, whoa, we don't want a patchwork of regulations. You should wait for someone bigger to do this. And then in the meantime, you have people like this Joseph McGuire who are saying, this has destroyed my life. Marianne, what are your thoughts on this?
Well, I'm kind of curious what the specific marketing is in this case, and I don't know. The lawsuit, if you look at it, says that they represented that it was a safe product. I don't know what that means. Did they say it's non-addictive? Did they say it's okay to take this? Anybody and everybody can take this? I also was thinking about other kinds of unsafe products that people buy and use knowingly and have no claims. I was thinking about things like snowmobiles and skydiving and four-wheelers. People use them and they know they're unsafe. So I just don't know enough about what the specific marketing was.
I think that's a great question on the specifics of the marketing. You're thinking about snowmobiles. I'm thinking thinking about alcohol. I'm thinking about all the problems that has caused for so many of us. And yet I don't think I would be successful if I tried to sue the makers of Bombay Sapphire.
That's a good point. Here, what the proponents would say of this is that it's some kind of dietary supplement and can be used to relieve pain. The problem is in its failure to warn of the addictive use of these products. I mean, it's very my research suggests is the substance use disorder quality is very strong and is very similar to these opioids. So it's not necessarily the same if we're talking about skydiving. You're going to have certain warnings about what those risks are. But, people, the people that are pushing this product are saying, oh, well, it's good for, dietary reasons, or it's good to relieve pain. But it's also extremely addictive, seemingly.
Yeah. And is that how you were able to successfully pursue the opioid companies, that they were saying, you're going to heal from your ankle surgery, and that it had all these side effects?
My ego would be too big to say that it was just me. I mean,
Sure.
There was teams of attorneys throughout the country. But yeah, essentially a lot of the evidence that showed that these companies knew that this was an addictive product basically hid that in their marketing and really pushed these drugs out into the market.
And I see a lot of similarities in this case with the opioid epidemic, lead paint, asbestos, cigarettes, and the common denominator is the companies always lost. And I think that the Kratom folks are going to lose this one as well.
Yeah, so maybe you can have a good run and make money off of asbestos, but eventually you have to pay the piper.
Yes.
So the state of Missouri lost a round in its case against, of all things, Starbucks. Now, we talked about this months ago when it was filed by Attorney General Andrew Bailey. The state is suing the coffee giant, saying its workplace had become, quote, more female and less white since 2020. Seems like somewhat of an unusual lawsuit. Judge John A. Ross agreed that it was somewhat of an unusual lawsuit. He said that Missouri failed to allege, quote, any actual adverse employment action undertaken resulting from unlawful discrimination by Starbucks. But Attorney General Catherine Hanaway, she says she's going to appeal. Marianne, do you think she has a better chance with the 8th District Court of Appeals?
No, I really don't. The anti-discrimination statutes were created to provide the opportunity for people who believe they've been discriminated against to bring a claim. In fact, it's interesting because plaintiffs in these cases are often referred to in judicial decisions as private attorneys general. They're taking the lead in getting a good result to assure that these big corporations follow the law. But in this case, the Missouri Attorney General couldn't point to a single white male person who didn't get a job or got fired from a job or got demoted from a job. So, I mean, my personal opinion is that this was political grandstanding and that the continued follow-up and the appeal of this thing is, again, political grandstanding.
It seems like with these, you normally want to have some sort of like poster person who can be in there and say, I applied 7 times. I've got this great resume. I was discriminated against. Could you ever successfully bring a lawsuit like that without this? I mean, Marianne's pointing to this as a defect. Could you bring a statistical case, perhaps?
I don't think so. No.
You know, you can bring a thing called class actions, but you have to have employees to represent the case whose claims are similar to the members of the class. So you got to find somebody who's been aggrieved, who's been treated unfairly, and has a claim of their own to bring that kind of class action.
So I can't just bring a class action saying, hey, I know there's people out there. I will find them after I file this lawsuit. I have to have someone to stand in for that class.
And usually you have to have several people who have various characteristics to be representatives of the class. You know, the other thing is, I don't even know how the Attorney General had standing to bring this claim in the first place, because if you look at the definitions in the statute of who's entitled to bring a lawsuit, it's not the Attorney General, unless there's a person aggrieved.
Patrick, do you think Marianne's wrong here? Do you think that the Eighth Circuit is going to excitedly take this one up?
I'm certainly not going to step on Marianne's background as an employment attorney. What I looked at is what is the actual discrimination here. I'm not an employment attorney. Sometimes some of my work will touch on some of these aspects of employment, but I just don't see where any actual discrimination was made against anybody, and that seems to be what the judge said. There's nothing here.
The other thing is, I don't think we should be surprised that the employees of Starbucks are becoming more female and less white, because these are really not very well-paid jobs. And that's the kind of ghettoization that happens to non-white females. Just generally, they end up having a higher concentration in the lower-paid jobs.
Mm-hmm. We're talking today to our legal roundtable. That is attorney Marianne Sadeh with Sadeh Harper Westhoff. We're also joined by Patrick Hamaker of Mandel and Mandel and Eric Banks with Banks Law. We're going to take a quick break here. When we come back, we'll talk about a St. Louis County police officer who was disciplined over an annoying email. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm the executive editor of St. Louis Magazine. I am filling in today for Elaine Shaw as we convene our legal roundtable. And this month, that includes Patrick Hamaker, who is a former prosecutor for the city of St. Louis and currently with Mandel and Mandel. We're also joined by Marianne Sadeh, who's a partner at Sadeh Harper Westhoff. And we're joined by Eric Banks, a former city councilor for the city of St. Louis, an attorney and mediator at Banks Law. So a police officer in St. Louis County was disciplined over a reply all email that, it did strike me as pretty annoying. Officer Christopher Douglas says that he received a county-wide mass email. It was acknowledging Hispanic Heritage Month. Well, it happened to be September 11th. So he fired off an email. Here's what it said. I may have missed, but will there be a ceremony on this day, September 11th, 2025, remembering and honoring those heroes lost on September 11th, 2001? Well, within hours, he heard that department brass weren't happy. He was soon transferred from criminal investigations to patrol. He's now suing. He wants to get that old job back. Marianne Sadeh, is this a case you'd take?
Well, probably not, and I'll get to why not. I do think that he was entitled to due process. And so I think he may have a claim under due process because, the lawsuit says that he was demoted, that he has less benefits, that his hourly rate is less, that he has less opportunity for overtime. He doesn't get to take his car home anymore. There are a lot of ways in which you can see that there was actual economic harm there. What due process requires for public employees is, notice in writing of what you're going to be adversely treated for, and a meaningful opportunity to respond. But in many cases, that's just a meeting with the guy who's probably going to fire you anyway. And so, I wonder what this guy's remedy is. In the end, is he just going to get due process? Because if in the end what he gets is due process, the result is probably going to be just about the same.
So they could say, hey, you won this lawsuit. We have to give you due process. We're going to sit you down and tell you why this was wrong. You get to state your claim. Okay, we're demoting you anyway. Yeah, that's not a great outcome there. Do you think if they had used due process, they would have the right to demote him over an email of this sort?
Well, one of the things I'm sure of is that he's a member of a police union and that there is a collective bargaining agreement. So he may have some right to be only fired for cause. And whether this is just cause is, an interesting and open question. Again, one that I think a jury would ultimately decide. But I don't think they're going to get to that. I think they're just going to give him due process.
And we should note here, he wasn't actually fired, as Marianne said. He was demoted and suffered a number of things because of that demotion. Patrick, what do you think about this case?
Yeah, I was very interested to hear what would be the recourse on this. I mean, it seems pretty clear that his due process rights were violated. The ultimate question is, can you be fired over this statement? I really don't know. I do think that would be something with the union and part of their collective bargaining agreement. But it seems pretty clear that he didn't get his due process rights, and he deserves those. And I do think a judge is going to say, yeah, he's got to go through the process. The outcome of that's really hard to figure out.
It feels like this email was trolling. Like, it feels like he's like, oh, I'm making it about the heroes of September 11th. But he was really criticizing what we now often see being criticized, which is DEI, something that would lift up Hispanic brothers and sisters. Do you think the department could make the case, if it came down to the merits of the case, to say, hey, you've got to interact with Hispanic people when you're out policing? This is a problem.
Yeah, they can't make that argument. I think that they're not going to be successful with that argument. But I don't think the punishment fits the crime. I think that if he probably should have had a nasty gram put in his personnel file and just don't sin like this anymore. And that should have been the end of it. I think for somebody to be demoted, lose benefits under these facts was quite egregious.
You can tell that whoever was the decision maker here was just angry. They were fired up because they know how to do due process. They do it all the time. I mean, I have these clients and, I say to them, sure, I can go to your due process meeting with you. If he wants to fire you, he's going to fire you. There's not much I can do to help you. Do you really want to give me your money? I think the outcome would have been the same.
I will say, regardless of the content of the email, the reply all is a scourge upon our society. It drives me crazy. If this was somebody that did this in my office, I could see myself reacting very hastily in a way I might later regret.
And how can the county have a system that would allow reply all? I mean, a mass email, it should go do not reply or something of that nature.
Eric, you have got at the heart of this story here, really, when we think about it. That is a broken email system that allows just anybody to show up in the inbox with their comments in response to this. Learn how to do a BCC to yourself,
Absolutely.
We employment lawyers, we love reply all because people say things in reply all that they had absolutely no intention of the individual who's affected by it knowing about, and it's like, oh, look at that, So yeah, it's not a good idea.
Well, here's the moral of the story today. I thought it was going to be about, you probably shouldn't talk to the media when you're in trial. You could get a mistrial. The real advice is don't send a reply all email. The employment lawyers they are sharks in the water looking for the bad email there. So let's talk briefly about data centers. This is certainly the topic du jour here in Missouri. Neighbors are trying to stop one that was approved by officials in Montgomery County, but they are coming at it saying, hey, the county failed to post tentative agendas that could have advised the public what's going on, that they took actions in unlawful closed sessions. They're saying, you got to avoid this entire project. I'm wondering if this is something like the due process that Marianne was just describing. If they did something in closed session they're not supposed to do, and this lawsuit is successful, can they just come back in open session, do the same thing, and the public is stuck with the data center?
Yeah, what I thought was interesting about this lawsuit, so this is out of Montgomery County, and it seems to be from some individuals who believe that public notice and about when a meeting was going to take place and what the agenda was going to be is the basis. Now, there's other claims for sure, and those kind of go more towards, I thought, the merit of these data centers. But when you kind of look at those two items, I pulled one of the agenda items from Montgomery County, and the agenda is pretty clear on what that they're going to be discussing, at least from one of the agenda meetings. And, there was a lot of these commission meetings where they're deciding on the data center. The other thing is on the notice, the lawsuit, the people who brought that lawsuit, they contend that posting on the county's Facebook page and clipboard in the commission's office isn't enough notice. Under the law, it says posting the notice on a bulletin board or other prominent place that can be accessible is enough. And I'm not an expert necessarily on this, but it seems like posting it on a clipboard in the commission's office where the meeting is going to be taking place is probably enough.
It's interesting. It seems like maybe it's the law that needs to change here. I mean, these days it seems like you could make a requirement that you have to post it on the government website. A whole lot more people would see it. But if that's not what the law says, that could potentially be a problem. Marianne, any thoughts on this one?
Yeah, it does seem like an area where the law has not caught up with reality. Yeah.
So let's talk about a different matter involving a municipality, neighbors that are trying to take action. This lawsuit is over a historic home in Kirkwood. Now, it seems clear from everything we know about this home, this is not a home that needs to be destroyed. The previous owners put a lot of work into it. A person paid a good amount of money for it. But now they have sought a permit to try to say, I need to destroy this home. It's not going to be able to be updated to what my family wants. Does the city have the power to stop them? They're under a lot of pressure right now to do that. Stuart Keating, who's the executive director of the Landmarks Commission of St. Louis, he's kind of urging them to say, hey, you do have the power to stop this demolition. Patrick, do you think he's right about that?
I don't. And it goes back to what we're talking about with putting together good laws that are thorough and make sense here. So the Kirkwood Landmarks Commission, they are essentially an entity in Kirkwood to preserve landmark homes and or historic districts. The equivalent that we would have here in the city of St. Louis is the city's preservation board. However, the only power that the Kirkwood Landmarks Commission has is to put a stay when there's a demolition for 270 days, which is 9 months. And generally in the past, that seems to have worked. And that's probably because if you're somebody who wants to come and renovate a house, you're going to have to sit on this thing for 9 months. And, developers don't really like to do that. And it also gives maybe another idea to have that time to reconsider demolishing a home.
Public pressure might get to you during that time period.
Correct. And in this instance, they've waited the 9 months and they're ready to demolish it. What we see kind of around the country when we're talking about preserving landmark homes or historic districts, which I'm, in favor of those in general, is also balancing individual property rights here. And so, unfortunately, what they have in Kirkwood is their only mechanism is to do this stay versus, at least when it comes to asking for a variation of something in the city of St. Louis, you go through the preservation board. Well, then there's an appeals process that takes you to the circuit court and then to the Court of Appeals. There's nothing laid out in their ordinances to say to be able to do this.
So in the city of St. Louis, they would have a lot more power to stop this thing, but that's just not how Kirkwood's rules seem to be written.
I mean, potentially, right? There's just more avenues to bring this lawsuit. This lawsuit is kind of based on a state historic preservation law that they're trying to imply that Kirkwood has this power. But it's what we're talking about. They're trying to imply that there's a power that they haven't put into their ordinances.
That's interesting. And it makes me think of something that just happened a couple days ago in St. Charles. There, the city council overrode the Landmarks Board. Now they're being sued by the developer. Eric, do you see some similarities between these two? They're sort of dealing with people who want to do something, and the people are saying, we want you to take action.
I do see similarities, but I also think that, and I am very pro-development, but it doesn't need to be on a floodplain. I don't think you should build anything on a floodplain that you're not prepared to lose. And it may be a 1 in 500 year flood, but still, you're not supposed to put up apartment buildings, hotels, recreational centers, anything that you're not prepared to lose does not need to be in a floodplain. It should be pickleball courts, like I think they have now already. It should be a running trail. It should be a green space. It should be a park. But you don't need to spend a multi-$100 million, put a project of that magnitude on a floodplain.
Yeah, this is a pretty big project they're talking about in St. Charles. Do you think the fact that this is a floodplain situation, that the St. Charles City Council is going to be vindicated? They're going to face down this lawsuit and win?
I think so.
Marianne, any thoughts on these historic preservation cases?
Well, I live in the city, so I love historic preservation. But, the other thing I wonder about the Kirkwood situation is whether these individuals who have brought the lawsuit actually, again, do they have standing to bring this lawsuit? I don't know. I don't know how they're affected other than the fact that they live in the city of Kirkwood.
Well, and that's a good point, because what we see in this St. Charles lawsuit is actually the city is bringing their lawsuit to basically change their ruling. And in their ordinance, according to what I saw, is that the person can appeal a decision from their landmark commission if they're an adjoining landowner. And technically, St. Charles is the adjoining landowner, so there's a standing. But that's a very, very good point in this Kirkwood lawsuit. I struggle to see that as well.
Now, it may be that the people who brought the lawsuit are residents of the same historic district. I'm not sure, because that was not readily discernible to me from the things that I was reading. But maybe if they live in the district, maybe they have standing, but it's a tough one. It's a tough one. The other thing is the whole concept of implied power. Man, if you got to imply a power from a law and it's never been done before, that's tough. That's a tough thing to prove.
So I'm going to squeeze in one last matter here in our final 3 minutes or so today. So Republicans in Jefferson City want to reorganize the appellate court system. They've introduced a bill to move the Cole County Circuit, which hears many cases involving state government, into the Eastern District Appeals Court, not the Western one it's in. Now, as somebody who just always wants St. Louis to have more power, I'm like, okay, yeah, bring that over to our district. Marianne, is it that simple?
It's really not. It's interesting. They are requiring that all constitutional cases will be brought in Cole County. Right now, you don't have to bring constitutional cases in Cole County. People tend to, but you don't have to. So they're now going to say all the cases interpreting our Constitution are going to be decided in Cole County, and we're moving Cole County over to the Eastern District. And really, it's sour grapes. It's like we don't like the decisions of the Western District. When you look at the makeup of the Eastern District versus the Western District, it's not that different in terms of politics. The other thing is, it just seems to me that it's terribly cynical to decide that judges are going to make these decisions based on politics. And interestingly, the only people who testified in favor of this change were the pro-life organizations, because they don't like the decisions that have been made in the Western District on abortion issues.
It's interesting. I think about lawyers from Kansas City. I think about lawyers from St. Louis. I don't think of those St. Louis lawyers as likely to give you a substantively different response than Kansas City lawyers would when it comes to an issue like reproductive rights. Eric, do you think, is the Kansas City district, this is more liberal?
I don't think so, and I have the benefit of having lived and worked as a lawyer in Kansas City. And I believe that there are more similarities than differences between Kansas City and St. Louis. Uh-huh. They say that Kansas City is the easternmost western town, and St. Louis is the westernmost eastern town. St. Louis wants to be Chicago. Kansas City wants to be Denver. But other than that, the similarities are about the same.
Yeah, and I would imagine the legal community probably has even more in common. Patrick, do you see anything good that could come out of this litigation if they say, yeah, let's move this over to the Eastern District?
No, I hate this. I would hate this if Democrats were doing this just as much as Republicans. And the other sneaky thing about this is they wanted to move it to Cole County because the way that they elect their judges is different than what we do in the city of St. Louis County, Springfield, and Kansas City, where we have the nonpartisan court plan, where we have people who are picked by a commission, of which I should disclose I am on that commission here in the city of St. Louis, and it's to take the partisanship out of it. They want to move it into a venue where where it is partisan. People are running with an R and a D, and then they have that first start. So I wouldn't like this no matter which party was bringing forward it. I don't like it at all. I think it's so partisanship, and it's not, it goes against kind of everything that I believe in when it comes to the nonpartisan court plan.
Well, it'll be interesting to see if this advances. I feel like there's always talk about changing things around with judges, and ultimately cooler heads prevail. So we will see. We will undoubtedly talk about that in a future legal roundtable, because that is it for today. Patrick Homaker of Mandel and Mandel, thank you so much for joining us. Your first ever time on this roundtable.
Thanks. It's been a pleasure, Sarah.
And thank you also to Marianne Sadeh of Sadeh Harper Westhoff.
It's always a good time. Thank you so much.
And Eric Banks of Banks Law, thank you for joining us.
This was a lot of fun.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.